Tao Falilelo Jr. and Lex Logistics. Case number 2020-00460.
Good afternoon, Your Honor. John Butler, P33908 on behalf of the plaintiff.
This is Alexandru Leahu for Lex Logistics.
Okay, all right. So today's date and time set for a hearing. The plaintiff is wishing to, or requesting of the court to grant a default judgment against Lex Logistics. Is that correct, Mr. Butler?
It is, Your Honor.
All right. Do you understand what's going on today, Mr. Leahu?
Welcome back to Courtroom, where real cases reveal what happens when everyday people find themselves tangled in legal chaos. Today's hearing is a perfect storm of confusion, frustration, and financial risk. On one side, we have Tao Fellow Jr., an employee whose legal issues sparked a wage garnishment. On the other side, Lex Logistics, the employer led by owner Mr. Liu, who claims he had no idea what was going on. But ignorance of the law is no defense. The stakes? A potential $25,000 judgment that could crush his company. The courtroom tension builds fast. The judge is calm but firm. The plaintiff attorney is laser-focused. And Mr. Liu seems completely out of his depth.
Tao used to work for me. He doesn't work no more. I don't know where he's at and all that. And I'm not really familiar with all this kind of laws, but I don't have to be garnished for nobody. I don't see how did I receive all kind of whatever stupid stuff what the person who used to work for me, I don't know, apply and all that. To be honest, I'm not familiar at all.
So, Mr. Leahu, the way this works is if you have an employee, okay, who has a court case against them and they owe money, the person who is owed the money, they can get a part of their wages, and you would have to participate in that. And that's why Mr. Butler and his client is looking for that information to see if monies that Tao Falelo, monies that this person earned, that Mr. Butler's client has a right to a portion of it, that they're able to successfully get those monies. And so you're saying right now this person does not work for you?
No, it doesn't work for months and months. No.
When did he work for your company?
Last year.
Your Honor, I see that the wage garnishment was filed. Looks like October 4th, 21. We sent a failure to disclose letter in November. No response. We entered a default against the garnishee defendant last November. No response. And now we're seeking a judgment.
At this point, we see the classic courtroom dynamic. The plaintiff's attorney presenting a paper trail of unanswered notices, while the defendant stands there confused. It's not malice, it's neglect. Mr. Liu admits he didn't understand, but that doesn't hold water in court. Here's the truth. Once a court sends you a garnishment order, you are legally obligated to respond, even if the employee no longer works for you. Every ignored letter adds up to potential penalties. The attorney's tone is calm but firm. He's painting a timeline that proves total noncompliance. You can almost feel the judge's patience wearing thin. It's like watching a slow-motion car crash where everyone knows the outcome, except the driver.
Seems like if he would have simply answered the garnishment when it was originally filed, we wouldn't be here today. And if he's not a lawyer, perhaps he should talk with one. But we've had to do a lot of extra steps that would have been helped by filing the garnishment when he was required to.
Well, when the request ultimately is for a $25,000 judgment against Lex Logistics, I think it would be probably appropriate for the court, especially if it sounds like Mr. Falelo didn't work there all that long, that Mr. Leahu have the chance to at least talk to a lawyer about this. Mr. Leahu, you have an obligation when it's not court stuff is definitely not stupid stuff, because it could absolutely have a huge impact on you financially.
Let's pause here, because this is where so many business owners mess up. Mr. Liu admits that he tossed out the paperwork because his own name wasn't on it. That's a dangerous misunderstanding. The law recognizes businesses as entities, meaning the company itself has obligations, not just the individual. So when you ignore something addressed to your business, the consequences still fall on you. And in this case, that mistake is worth $25,000. The judge isn't being harsh here. He's being realistic. When you run a company, paperwork is part of the job. Missing a form may seem small, but as this case shows, small things in law can have massive financial fallout.
But that being said, if you don't have to deal with this very often, it would be something that is new.
In 20 years, I had some companies in 20 years. First time when I ever saw something like this, to be honest, I saw that it's not on my name. I said, Lex, I never pay attention. Now, when I got it, the last one, I really look a little bit into it, and I start pretty much look into the meaning of garnish and all that. And then I start calling your court and all that. And I say, hey, what the heck this one has to do with me? And then they start explaining me that I have to show to the court. I have to explain to you that he doesn't work for me and all that. But for me, maybe if somebody called me, explain me more about it. But I didn't even pay attention to the sum, to nothing. Once I didn't see my name, I get 100 stuff in my mail for a company. To be honest, if it's nothing, I know I didn't do nothing wrong. I don't pay attention to this kind of stuff.
Right here, we see frustration taking over logic. Mr. Liu keeps saying, I don't know what to do, and it's not my fault. But from a psychological perspective, that's denial, an emotional defense mechanism kicking in under stress. He's overwhelmed. But instead of asking the right questions, he's venting. The judge, though, remains composed and even empathetic. He gives him 30 days to consult a lawyer. That's rare patience. Many judges would have just granted the default judgment on the spot. This scene reminds us that courts aren't always cold or cruel. They can give people grace. But grace doesn't erase accountability. The clock is ticking, and the window to fix this mistake is closing fast.
Talk to a lawyer, because these answers, like I didn't know, or, those aren't valid legal answers for your failure to answer this garnishment back last year. So I'm willing to discuss these things, but you need to talk to a lawyer about this, because right now, Mr. Butler is looking to get a $25,000 judgment against your company. $25,000 judgment against your company. I would think at that point in time, it might make sense to talk to a lawyer. I can't tell you what to do. I can't give you advice. In my position, if I give you advice, then it looks like I'm showing you favoritism over the other side. I can't do that. And so, Mr. Liu, I'm sorry that you haven't had to deal with this in 20 years. Thank goodness you haven't. But you're having to deal with it now. So I'm going to adjourn this 30 days. You might not have to hire an attorney, but you can at least talk to an attorney. So use that time. I will tell you.
Okay, but what do I have to do if the only thing what I can tell you, he doesn't work for me and all that? Even if I talk to a lawyer, what can I do in this case? Because I don't have nothing to do to this person, and I don't have no idea what kind of loan or what.
Now the judge delivers one of the most powerful teaching moments in any courtroom clip. He says, an hour versus $25,000. I can't understand that conceptually. That's the heart of the issue. The defendant spent months ignoring a problem that could have been solved with a single phone call. And this is where legal reality hits. Court deadlines don't care about your schedule. If you're a business owner, every unopened letter could be a ticking time bomb. This isn't about big corporations or legal jargon. It's about responsibility. 1 hour of attention could have saved him from thousands in debt, but instead, he's now fighting to avoid financial disaster.
But he did work for you, and there was a time where they notified you, the other side, that's basically said, hey, if you're paying this guy some money, a portion of it has to come to us. And you didn't answer that. And that's a problem. And so that's right now, he's not working for you. That's fine. Then you don't owe them like any monies going forward. But there was a period of time where he was working for you, you need to talk to a lawyer about what your obligations are at this point when it comes to Zeal Credit Union.
Okay, and what we can do right now, because I cannot go back and forth even right now. I had to stop work for 1 hour just for, I don't have no work.
Sir, if you find, if you call the local bar association, if you look
okay,
for
but
a
what
business,
do I have
if you
to
look
do
for a
in this
if you
case?
look
Okay,
for,
what do you want from me now? Okay, this guy doesn't work for me. What do you want from me?
Mr. Leu, you need to stop interrupting the court. That's what needs to happen first and foremost. Stop interrupting me. All right? So I don't have to, frankly, right now you have no good answer for this. And the court could simply grant his motion for default, and then your company would have a $25,000 judgment against it. Why? Because you weren't willing to take a couple minutes, an hour. You say it's taken an hour versus 25,000. I can't understand that conceptually, sir, why you wouldn't.
This is only in this country can happen for me to own to somebody else some money, and I have to deal with this. You're telling me that it's my fault that I didn't pay attention.
This exchange is almost hard to watch. The judge is practically spelling out the solution. Find a lawyer. Respond properly. Fix this. Yet Mr. Leu keeps circling back to the same complaints. It's a moment that perfectly captures the gap between what people think the law is and how it actually works. The judge's tone shifts slightly here, from educational to firm. He's giving one final lifeline, but he's making it crystal clear that the court won't entertain excuses twice. Viewers, this is a line between mercy and consequence. The next move is entirely on the defendant, and his company's future depend on it.
How should I, if I never pay attention to the money and all that, I didn't do nothing.
Sir, if you're a business person, then you are held to the same standard as any other business person running a business in this state, in this country. And that is, if you get a request of this nature, you're to respond to it. And you didn't. And so I'm giving you a chance here to talk to a lawyer and see what your options are. Now, you say you don't know anything about this. There are so many lawyers who do. And you say, I don't even know what to do or what to say. If you hand these documents to a lawyer, they will know what to do. So I'm adjourning it 30 days. If you want to come back here and say, I don't know what's going on, I don't really understand, and I've given you 30 days to go find out, then I'm not going to have a lot of patience for you, Mr. Leu. But I'm giving you 30 days to have a conversation that probably will take less than an hour.
Tell him to send me again the paperwork, because I don't have the paperwork no more. I just made a screenshot for this court date. Tell him to send me another copy of those. I'll look into it with the lawyer, and that's it.
I would say talk to the lawyer about that. He or she can call Mr. Butler for any documentations that are any paperwork that's outstanding. I'm sure you have Mr. Butler's phone number. If you contact, if you give your lawyer, Mr.
No, I
Butler's
don't have nothing. I just made the screenshot for my meeting ID, and that's it. I don't have nothing, to be honest.
We said, how did you know about today?
Because I made a picture from that letter to the meeting ID, and that's it.
The meeting ID has the notice has Mr. Butler's the other attorney's name and number on it.
But I called him at that time when I call your court to look into this, and I throw the paper away. I don't have it no more.
This moment says it all. He literally admits he threw the document away but kept a screenshot of the meeting link. That's like tearing up a contract, but keeping the Zoom invite. It shows how deeply disconnected he is from the gravity of the situation. The judge's expression here says it all. Disbelief mixed with restraint. Lawyers and judges live by paper trails. If it's not on record, it doesn't exist. Mr. Leu's casual attitude toward documentation could cost him everything. And for anyone watching, let this be the ultimate reminder. If it comes from a court, it matters. You don't toss it. You don't delay. You act immediately. And that's where today's hearing leaves us, with a business owner standing at the crossroads of accountability and consequence. The judge has given him 30 days to get his act together, but that's not guaranteed salvation. If he fails again, that $25,000 judgment will hit hard, and Lex Logistics may not recover. This case isn't just about one mistake. It's a warning for anyone running a business. Read your mail. Respond to legal notices. Take action before it's too late. Because in court, silence is never neutral, it's costly.